This is the abbreviated summary of class 3 to 5, which is going to take us pretty much up to the first break. And this is designed for students who want to just refresh their memories of what happened in class. And perhaps if for whatever reason you weren't able to attend, this will give you some idea of what exactly you missed. It isn't, though, a substitute for attending or for doing the necessary reading. Where we left off last time round is that we were talking about the various developments post-1945 in the world of international arbitration, and in particular, the things that sprung initially from the New York Convention, and then from the various legislative reforms which were really triggered by the 1980-81 French clean out of their laws. And that took us firmly up to the recent developments, which is the fairly modern change in the Swiss legislation that came into force early this year. So what you have here, in fact, is some conventions, international gatherings triggered by the New York Convention, often involving quite a few of the same people, by the way, and then emerging into a legislative reform package or program that one can see started in a way by the Concordat of 1969, which came into force in 1972, and the various yearbooks which gathered information about arbitration around the world, the French legislation, the model law, the Dutch, who reacted to the development of the model law by redrafting their own statute, the Swiss, who then had another go at the Concordat for international cases here only, the English, the Germans, sort of it surprised actually a lot of people by enacting a form of the model law. The Swedes did a sort of rewrite, but which they claimed to be the model law, but isn't. Then there was a tweak to the German statute, the big revision to the model law. The French redid their statute, but didn't change it drastically. The Belgians had a rewrite. The Dutch tweaked their old legislation from 1986. The Swedes did a redraft in 2019, which is surprisingly easy to confuse in real life with the 1999 version. To be careful you're looking at the right version. And then finally, the Swiss LDIP amendments. And that brings us up to the end of the previous video. The core concept in modern arbitration has always been the seat of the arbitration. Its origins lie in the horrendous SE in Yugoslavia case, of which more in a moment. The key trick here is that the modern consensus says that the parties can choose the seat of arbitration. If they fail to do so, the arbitrators could do it, or any other organization that the parties have agreed to allow to select the seat of arbitration, typically an institution. The normal sequence actually is parties choose, they don't choose, but they have chosen an institution, the institution selects, and if it's an ad hoc arbitration, the arbitrators choose the seat of arbitration if the parties haven't got round to doing it themselves. The key here is that the seat of arbitration typically sorts out which arbitration law you need to study. It should probably also deal with the law governing the arbitration agreement, but the English court, Supreme Court notably, in the Kebabji case, made a bit of a mess of that by concluding that an express choice of law to govern the substance of the contract, if not expressly limited in those terms, will in fact govern the arbitration agreement, which is a bit strange and makes a bit of a mess of most of our understanding of how arbitration works. So in that case, the seat of arbitration had been chosen by the parties as being French, but in fact, the law governing the contract was English. The English Supreme Court construed that to apply to the arbitration agreement, and thereby declined to apply French law, which would otherwise have decided that the parties to the arbitration were those that actually had included, I should say, the company that took over the franchise rather than the original franchisee. But arbitration proceedings can take place anywhere. There has never been any particular rule that says a hearing must take place in the seat, although in real life there is a certain compulsion towards arranging something to happen in the seat of arbitration, because the parties have chosen this location typically, or an institution has thought that it was a pretty good idea as a place where hearings could take place. There are exceptions, though, and it's worth pointing them out, that you choose a seat of arbitration in a variety of ways. The Court of Arbitration for Sport has it in its rules that the seat of arbitration is always Switzerland, Lausanne in Switzerland, and that might be totally unconnected to the dispute and may in fact never be involved in the dispute in the slightest, but it is where the head office is. There are some practical decisions to be made. You've got to end up in a neutral place that isn't a million miles from all the parties. It's a bit silly to choose a perfectly lovely location in North America, for example, to handle a dispute between an Indian and a Chinese party. Singapore makes a good deal more sense. You want the legal system to work. It's always been the negative for choosing France. The legal system is desperately slow. And where you have issues with the integrity of a legal system, then you really don't want to be arbitrating in that country. And for that reason, you don't want to be somewhere that's politically unstable, if nothing else. You must make sure that the IT works. So good Wi-Fi, good communications, good transport links are vital. And make sure that they're not going to change. So anything that's a bit unstable, you don't want to be there. If there's been a recent civil war, that's not a good seat of arbitration, because you cannot guarantee that there won't be another one. And the result is we end up with a remarkably stable set of statistics coming out of the International Chamber of Commerce, who are not by any means the only administrators of international arbitration, but they do actually serve as something of a bellwether for where things are. And the number in sequence has always been France, Switzerland, actually it's England, then USA. France and Switzerland have slightly odd numbers because France is often the seat of arbitration, because people remember that the ICC's headquarters are in that country and sometimes choose France by accident, not realizing they could go somewhere else. And on occasions, the ICC will select France as the seat of arbitration for the practical reason that they're not very sure the parties didn't choose it in the first place. So Switzerland on occasions has been number one as the seat where the parties have selected a seat, but France overall ends up as number one. A few things about France to say that we've already mentioned. It's where the ICC has its head office, long tradition, tremendous publications. The CPC, it used to be the NCPC, the nouveau one, but a bit like Beaujolais, best drunk early, because after a while it wasn't quite so new, and eventually somebody got around to removing the N from the front of it. It's a language that a lot of people speak, French, and Paris actually has a lot of very good English speakers to choose from as arbitrators, so it's not quite the issue that it might be in other countries. Switzerland plays on its neutral card. That's its big plus. It's also very good language-wise, and one of the changes in the LDIP and now allows the parties to file papers with the courts relating to arbitration in English, which makes a good deal of sense. Lots of international organizations have been present as help. The trains run on time, the electricity works, the telecommunications are superb. They do have this rather strange setup whereby the chambers of commerce have got together to create an institution which in turn has adopted the Swiss rules. These are not Swiss law, They are simply institutional rules which apply where the parties have chosen their arbitration to be governed by the rules of the chambers of commerce that have signed up to the institution in question. It's actually slightly bizarrely run now by the Swiss Arbitration Association, or at least owned by them. The LDIP only covers international arbitration. Actually, the parties could exclude the application of the LDIP in favor of the Swiss rules on domestic arbitration if it chose to, although quite why one would, I don't know. It does very occasionally happen. The Swiss domestic rules are now contained in the federal law on civil procedure, which was adopted after the Swiss constitution was changed to make it clear that procedure was no longer a matter for the cantons, the individual little statelets that make up Switzerland. So that would be the situation in a purely domestic arbitration. And that law is in fact the successor really to the Concordat. But beyond that, there is one other element you should bear in mind. There's a single instance setting aside proceeding. So you apply to set aside the arbitration award directly to the Swiss Supreme Court or Tribunal Fédéral, which isn't quite exactly what a Supreme Court means, but it's more or less what we mean here. And that creates a single instance. You don't get multiple appeals, which does save an awful lot of time and effort. England, famous because its sort of maritime history gave it a sort of step up in terms of the shipping commodities scene. That generates a lot of arbitrations, quite a number ad hoc on the shipping side. On the commodities side, quite typically, the trade bodies like GAFTA and FOSFA are where these cases happen. There is what you could loosely describe as some form of domestic international arbitration. It's sometimes been described as not being international arbitration at all, which I think is wrong. The parties are very typically not English, but they often insure their ships, the P&I clubs in the City of London. The parties often have accommodation in London, you know, keep flats in London, send their children to school and university here, while by being impeccably Greek or German or something else. So everybody gets to know the scene. There are a lot of repeat participants in maritime arbitration who know what to expect and could be said to be at home in London in that respect. And that's the sense in which it's localized. The English language is one of England's greatest strengths in this space. And I should add that the Arbitration Act 1996 applies to England and Wales, which is one law district, and it does apply to Northern Ireland, but not to Scotland. This is enormously important. Only the New York Convention bits on enforcing foreign awards that are contained in the 1996 Act also apply to Scotland. Everything else does not. The Arbitration Scotland Act has its entirely own and different regime, and Scotland's never been a great seat of arbitration in international cases. USA, well, we all know how big the USA is, but the thing that USA is special on, it has a phenomenal number of domestic arbitrations. The American Arbitration Association historically has administered far more arbitrations than anyone else, often what you might call domestic within USA commercial cases. There's a huge labor tradition of collective bargaining arbitration, which is not governed by the Federal Arbitration Act, but by its own legislation. Although labor arbitration in various forms often is covered by the Federal Arbitration Act, contrary, I suspect, to the intentions of the people who actually drafted the legislation, but there we go. The Federal Arbitration Act, which was put together in 1925, Part 1 has remained relatively untouched over the years and probably is in urgent need of a cleanup. Just to bring it up to date, it is, though, in some ways small but perfectly formed. There have been add-ons to reflect the USA's ratification of various international conventions. So Part 2 covers the New York Convention, Part 3, the Panama Convention. Beyond that, well, we can talk about types of arbitration really blue in the face. Commodity arbitration, look and sniff stuff you don't see quite so often now as you used to, where a sort of cargo was landed and damaged, and they would send an arbitrator out to inspect it and to take a view as to how damaged it was and what reduction in price would be expected, the arbitrator would produce an award pretty much on the spot, and we don't see so many of these anymore, but there's no reason why we can't have a revival of them. A lot of arbitrations happen without any documents. It's a lot more efficient, and there is no point in holding a hearing just to hear the sound of people's voices. You can, though, have the full McCoy, the full real experience. And obviously, the higher the amount of money at stake, the greater the push to have that oral hearing. It's an interesting question as to how effective oral hearings are at getting at the truth. We find institutions, ICC, LCIA. We've already spoken in this video of the Swiss rules, which apply to the Swiss Chambers of Commerce and are run in effect by an institution. Then you have ad hoc arbitration. That's arbitration without an institution. The English maritime tradition is to go ad hoc, largely because the parties know exactly what is expected of each other. And so it becomes like a customary institutional rule that is, or set of institutional rules that are effectively applying to these cases. Nobody just gets on with it without paying the expenses of having an institution. But there is a development in recent years, last 20 years, of these scheme or panel arbitrations. Some of them aren't even technically arbitrations. Things like disciplinary processes from sporting bodies, they tend to end up at the Court of Arbitration for Sport under a particular set of rules. In Hong Kong, domain name cases are called arbitration or governed by arbitration law. Strangely, the WIPO version of exactly the same procedure is thought, at least by WIPO, not to be an arbitration. I'm not quite sure that's right, but one day the courts will have to look at that. So we do see different sort of things, and arbitration is increasingly used as a form of appeal from a disciplinary body's decision by the athlete, but sometimes also by the sporting body. In theory, arbitrators are supposed to be the peer groups of the people involved. It doesn't always work that way. We'd like to see more technical experts, but unfortunately there are a lot more lawyers. And that's partly because if each party appoints their own arbitrator, the temptation is to have a lawyer to argue your side of the story. Whether that's a good thing or not is an open question. I'm not convinced that law professors make terribly good arbitrators, although there are one or two, notably law professors who are in fact practitioners at the same time, who come under the category of lawyer and therefore can chair a tribunal very effectively. What you must have, of course, is people that are neutral and who know the language. You can't run an arbitration if you don't feel comfortable in the language in question. You don't have to be a lawyer, and you don't have to be, if you are a lawyer, qualified in the legal system in question. If you're familiar with the rules that apply, that will probably do the job most times. You get 3 different types of appointments because you may have the parties agreeing on one individual as the right person to have. You may get an institution, and they don't have to be administering institutions. The Chartered Institute of Arbitrators doesn't really run arbitrations, but it does appoint arbitrators, and that's an example, and there are many other bodies like it. The other arbitration institutions, the LCIAs of this world, ICC, they'll appoint arbitrators. And you do also get the party appointed arbitrator, particularly in the context of institutional arbitration, where the institution reserves the right to reject the appointment. We now need to look at arbitration theory, and it's really poses a few different questions under a single wrapper. What do we mean by arbitration? What is it? How do we reflect that in the legal provisions on the subject might be quite different, and how the law should reflect them may be in addition quite different. So do be aware those three questions are not the same, and yet they're answered by the following discussion in much the same way. While it's good to know what you're talking about, it is often used as a way of reaching a destination. The French theorists, contractual theorists, often argued that an arbitration was a contract, not because they had a great feeling that that's what it was, but because it suited arbitration, and often the parties for whom these lawyers were advocating, to show that the case was a contract, an arbitration award is a contract, not a judgment, because of the ease with which contracts were enforced in France at the time as compared with foreign judgments. So, you know, that may affect a lot of the discussion and skew it away from a pure discussion of what should be on the table for this purpose. Where does it all start? Well, it may start with an accident. Chief Justice Cook rather casually said the arbitration clause being revocable in Vinyor's case. This triggers the view, if you like, that the arbitrator is an agent of the parties. Doesn't sound quite right. Merlin and Felix in France, remember, advocating for the contract, not a judgment view, in order to facilitate the enforcement of arbitration awards, argued something on those lines. And they also took the view that the contract was an incomplete thing which the arbitrator completed. That's not quite right for so many reasons. We'll see them later. But it stayed also part of our common law, because if you look at modern arbitration statutes in the English-speaking world, they all start off by saying the arbitrator's authority is irrevocable, an attempt to try and get rid of that loose comment in Vinyor's case, which, by the way, remained part of English law through the 18th century into the 19th century, mid-19th century, and was a constant problem for those looking at this issue, and remains, from the look of things, still part of the law of Alabama, where the case does not involve interstate commerce, so not strictly speaking within our purview, but the Alabama code, what I remember, makes it clear there are categories of case for which specific performance cannot be ordered, and one of them is an arbitration agreement. Anyway, we saw legislation come into force in England, notably in 1854, and then 1889, that gets rid of this notion of a revocable agreement, authority or agreement, to something a bit more enforceable. And equally, the 1925 Federal Arbitration Act, which supersedes laws like those of Alabama in the areas where the Federal Arbitration Act applies, typically interstate commerce with a few exceptions. The Federal Arbitration Act gets rid of revocability. This is a picture of Lord Mansfield, one of the great supporters of arbitration in the late 18th century. But well before that, the English Act of 1698 reflected an existing practice of judges referring parties to arbitration, try and get cases off the backlog, if you like. They will get the parties in front of them and say, no, really, don't you think you should agree to arbitration? And we'll make this a rule of court. And if either side behaves badly, they can be fined or imprisoned for contempt of court. Well, the 1698 Act, which was passed to try and clean out a problem created by a statute of fines and penalties, which created an issue with the sort of bond that was actually enforced in Vinyor's case. The 1698 Act says the parties could agree to have their agreement made an order of court. This could happen without any hearing, just by the filing of an affidavit, and the judge would just get on with it informally, and then this would produce the effect of imposing the penalties for contempt of court in this situation. We know that in 1746, out of the blue, because the previous year the courts had said the opposite, that in Kill and Hollister the court remarked that an arbitration clause was an ouster of the court's jurisdiction. Well, that makes it some sort of jurisdiction then, if it gets rid of it. And so Kill and Hollister can be regarded as an example of the jurisdiction theory in a very early format. Even stranger, Kent and Elstob, which actually reflected some earlier case law, it's not the first case on this, concluded that an award could be set aside for error on the face of the record in England. That's typically an administrative act for which error on the face is a known remedy. So that suggests an arbitration award as being some sort of administrative act. Lord Diplock actually in 1978 wrote that this was one of the worst mistakes made by English arbitration law, but a study of the first edition of Russell on arbitration, which came out in the early part of the 19th century, shows that error on the face was very much there as a form of review. Things took a turn in jurisdictional thinking, particularly in Germany in the 19th century. There was much discussion about what law should apply to certain things, which law. One of the views taken was, and which is stuck pretty solidly, is that procedural matters are governed by the lex fori, the law of the place where the proceedings are taking place. Well, that wouldn't work if with arbitration, if arbitration is a contract. The moment we start thinking in terms of lex fori and procedural things, we start to think that arbitration is a procedure. And we can see that happening in the judgment of Lord Herschel. Be careful though, because it's not the judgment of the court of the House of Lords in Hamlin and Talisker in the 1890s. Lord Herschel focused entirely on what law governs the arbitration agreement. He's not interested in the law governing the contract. You can read the other judgments in a slightly different way, particularly the view taken there that it was important for Scottish law not to be applicable in that instance, because under Scottish law, the arbitration clause would have been invalid. So Hamlin and Talisker is a slightly double-edged sword of a judgment. In Jürgen Jürg, the Swiss Supreme Court laid down a very black and white rule, which is to be admired for its clarity, if nothing else, that an arbitration is a procedure, and procedure at the time, actually until relatively recently, was governed by the law of the cantons, the little Swiss statelets of Switzerland, and not federal Swiss law, unlike the law of obligations, which in Switzerland is governed by federal law and always was, or at least was in 1915 and is now. Ironically, the USA has exactly the opposite situation, because in interstate commerce, the arbitration clause is governed by the Federal Arbitration Act, unless the case falls within some pretty minor exemptions. Otherwise, because there is no federal contract law in the USA, the underlying contract is governed by state law. Realistically then, the response to Merlin and Felix's view that the arbitration award was a contract comes out from a number of different places. The Del Drago affair at the turn of the 20th century reveals in a sense, the battle lines of discussions about arbitration theory. Weiss, in his report to the court, which is published, argued pretty much what Merlin and Felix said. In other words, that the arbitrators were the party's agent, and they completed the contract by issuing their award. Lene, whose publication record in this area is not great, not extensive, pulls this argument apart, in his opinion, which again is also found actually in Cluny. He said, look, come on, arbitrators aren't agents, they're judges. They don't act on behalf of anybody. They're supposed to be unbiased. And we know this because the law provides setting aside proceedings on grounds that relate to procedural inadequacies that we would never find in the law governing the challenge of contracts. Pillet sort of climbs on the back of this. He says, yes, sure, there's an arbitration agreement that launches the arbitration. I call it the launchpad theory. But beyond that, what we get is pure judgment, pure judging activities. It's nothing to do with contract. Niboyer was the man that wrote the latter editions of Pillet's treatise on private international law, and he throws out there, he doesn't argue for it, but he throws out the view that perhaps an arbitration involves a delegation by the state of its normally exclusive powers to judge things in its location. The problem with that argument is that if you have say a French party in a dispute with a Czech party and they agree to arbitrate in Germany, the German state wouldn't normally have the power to judge anything in that dispute. It's the parties putting the case in Germany, if you like, that gives the arbitration its validity, not the state of Germany, which really doesn't claim any monopoly over the judging of this particular activity. Francis Mann, who I did know and rather liked, and whose picture appears on this slide, positions himself in a slightly different place. His Lex Facit Arbitrum essay in the Liber Amicorum for Martin Donker, which is how it originally appeared, is actually a response, I think, to Philip Fouchal's doctorate. And Fouchal tried to argue that arbitration was some way detached from national laws. And Mann said that's a lot of nonsense. If the law of the place where the arbitration takes place does not allow the case to proceed, it cannot. That everything comes back to a law which permits this form of dispute resolution. Whether you call that a jurisdictional theory at all is actually quite open to question. But it does give primacy to the seat of arbitration, which is very much a feature of jurisdictional thinking in this space. Serville wrote his article around the time of the Del Drago affair. He said, you know, come on, the two sides of that argument are both wrong. Arbitration isn't a contract. It's not really a pure judgment either. It's a bit of both. And Georges Sauser Hall, whose picture appears here, argued extremely strongly for a law of the forum seat approach. He said, yes, the contract's important too, but it is a procedural contract. And Henri Batulski makes the very simple, succinct comment that an arbitrator is a juge privé, a private judge. And from this, or around this same time, you see a movement away from the Felix Malin Weiss tradition to a slightly more subtle approach. Bernard was a Belgian writer. He produced his great book just before the Second World War. Frederick Edouard Klein is more a creature of the 1950s. At least that's when he wrote his doctorate. Says, look, may not be a contract, but it is the product of a string of contractual relationships. The parties' agreement, the agreement between the parties and the arbitrators, and ultimately the arbitrators themselves. And in that respect, it is more contractual than anything else. Jacqueline Rublin-Davici, who died actually relatively recently, wrote one of the most astonishing doctorates of this period in the 1960s. If you want to criticize it, you have to say that she writes about arbitration theory as if it was universal, when she's actually referring almost entirely to French sources and French law as it was at the time. But that shouldn't detract from the enormous validity of what she actually had to say. She said, look, you can't really split the contract bits from the jurisdictional bits. They're all there. but there is contract in the arbitration agreement, but even then it's an agreement to judge or have some sort of judicial procedure. In that respect, it's distinguished from mediation. But even at the award stage, the contract is still in play because the parties cannot award something that the parties have agreed not to let them award. And in that respect, contract and judgment or jurisdiction run throughout the arbitration process in an intermingled way, to the point that it may not be all that helpful to try to split up the bits and call things jurisdictional or contractual. And therefore, one probably should look at arbitration in an autonomous way. The somewhat irony of the doctorate is that Rublin-Davici explains so brilliantly the jurisdictional or judicial and contractual elements that go to make up arbitration, that you cannot get away from the fact that she does, in a weird sort of way, support the argument she's attacking, descriptively at least. I'm thinking here of the hybrid theory, the sort of Sousa Hall world. And to say that it's autonomous creates its own problems, because what are you going to replace the jurisdictional and contractual analysis with? And the answer is not much. There is a nice essay by Bruno Oppetti, which argues quite strongly that arbitration should be seen as sort of part of the toolbox of dispute resolution. And actually, funnily enough, there's some historical support for that, because if we look at very informal dispute resolution, the person doing the judging or fixing or whatever you want to call it, often combined arbitration with mediation in trying to get the parties to understand each other and work with each other going forwards in a way that a modern arbitrator wouldn't or shouldn't. And in that respect, he's right. But the problem with this is that if you want to distinguish an expertise from an arbitration, you have to add in the parties' submissions that happen in an arbitration with non-expertise. And if you want to distinguish an arbitration from a mediation, you have to make the point that the arbitrator judges and the mediator is all about trying to help the parties reach some sort of agreement, obviously as a result of the parties agreeing to allow that person to mediate. So in that respect, just saying it's part of the toolbox doesn't really help. But ultimately, Jacqueline Rublin-Davici spent most of her working life in the family law area, as you can see from the picture. She did write something about multi-party arbitration in the 1980s. That's pretty much it. It's a great shame if you read a doctorate, which is utterly brilliant. So what is this seat of arbitration that we all get so obsessed by? Well, we've seen already the definition of it. So we don't need to revisit it, but we do need to get some idea of the story behind it. And the story comes really from SE in Yugoslavia. That's probably what inspired most of the thinking here. And as we'll see in a minute, the Swiss courts concluded that the arbitration award couldn't be enforced in Switzerland because it didn't meet the requirements of an arbitration award under Vaudois law. This is pre-Concordat Switzerland. Vaud was the area where is the canton in which Lausanne is located, and that was the seat of arbitration. But they weren't prepared to set it aside. André Ponchot, the draftsman of the Concordat, the creator of the seat of arbitration, you could argue, on the basis of his article of 1966, entitled Le Siège d'Arbitrage. He was one of the arbitrators in SE in Yugoslavia, and we'll see a bit about the Gotha-Virken effect. And that takes me to SE in Yugoslavia itself. The railway line still exists, or it did when I last checked, which wasn't that long ago. It went from Veleš to Prilep, and apologies if I've mispronounced the name. It's in the modern state of Macedonia. And these are the railway stations. This was the original party. SEE is really what came out of the Société Européenne de Crédit Foncier de Banque. And the railway line was to be built in 1936, and it was completed. And the idea was that the Yugoslav government would pay in installments. The arbitration clause was somewhat eccentric. Each side had its 15 days to appoint, and if they didn't appoint, the president of the Tribunal de Commerce, or Tribunal Civil de Lausanne, would make the appointment. Only if the parties, arbitrators I should say, disagreed about the result, would it be necessary for the appointment to take place of a third arbitrator. This caused absolute chaos, because under Vaudois law at the time, there had to be an odd number of arbitrators. And so if the arbitrators agreed, as they did in fact, the award that would result would not comply with Vaudois law. There was a provision that the arbitrators should reach a fair and reasonable result, act as amiable compositeur, but reach a final binding decision. The other problem was that the decision had to be rendered a month after either party requested a decision. I've never been sure whether this wasn't misunderstood by the courts, that maybe that they could have an arbitration procedure without a party requesting a decision as such, and the party could request the decision later. But either way, the court thought that the 1 month to issue an award was also not consistent with Vaudois law, and I can understand why. It's far too quick. Anyway, you can see what was supposed to happen. Money was supposed to be paid after completion. There was only one real problem. And even though there was an adjustment in the currency, was that in 1940, I'm afraid, after all this work was done, the Yugoslav government found itself located in Greece, where it didn't really have access to the checkbook. The French government, acting, at least so it thought, on behalf of SEE, did a deal with the Yugoslav government in 1950, which should really have concluded the whole affair, except that the Yugoslavs made a fatal mistake of failing to get the agreement of the SEE company to the deal. So in 1956, SEE, I suspect a bit short of money, appoints Georges Rupert, who's a maritime lawyer, at least he wrote a book on maritime law, as their arbitrator, and silence happened. So they go off to the president, the Tribunal de Lausanne, who appoints André Panchaud, a recently appointed Supreme Court judge, slightly odd appointment in that respect. And the book is that of Georges Rupert, the picture of André Panchaud. This was the award, and unfortunately they agreed on it. They hadn't got an odd number of arbitrators, which would have helped. They deposited their award at the Tribunal Civil of Lausanne, and the Yugoslav government said, hang on a second, we want that deposit removed and the award set aside. The court said, well, parties didn't agree to setting aside proceedings in Lausanne or Switzerland anyway. And these two features, the 1 month rule and the two arbitrators, is just not compatible with our law. So we won't say that it can't be enforced somewhere else, but it won't be enforced here. The Tribunal Federal, the Supreme Court, received an appeal. They said, well, look, SEE never really intended to enforce anything in Switzerland, so no harm has happened. There weren't any assets in Switzerland. And in a note on the Journal des Tribunaux, which is the sort of slightly lesser reporting system for judgments in Switzerland, existed at the time, Aubert wrote an article where he uses the magic words, the floating award, the sentence flottante, of which much has been written since. Was this award going to float around Europe or the world? Well, it started to look like it. The French government wrote to the Yugoslav ambassador and said, look, this shouldn't have happened. This arbitration award is outrageous. We're terribly sorry, we did a deal with you. There were attempts to enforce the award in both France and Holland. We'll stay with Holland to begin with because it's simpler. Initially, the Hague court in The Hague said, look, it's not an award because the Swiss court said it wasn't one under Swiss law. So it's not covered by the New York Convention. It can't be enforced here. The Hergierad, the Supreme Court in Holland, said that's nonsense. They said, of course it's an award, and it was rendered abroad, and the New York Convention must apply to it. So it goes back to the Hague, and the Hergierad both expressed concerns that there is a breach of an international treaty. But of course, the international treaty didn't bind SCE. And then eventually the Hergierad in 1975 said, you know, the award was actually set aside in Switzerland. The court didn't say so, but that's what it meant. And we won't enforce it for that reason. Not very logical, actually. Because one thing we can say is the Swiss court didn't set aside the award. The French, well, they were all over the place. Come on. It starts off in the Tribunal de Grande Instance of Seine, and they said, well, this is an international agreement that's being interpreted, which is odd because SCE wasn't a party to it. The Cour d'Appel de Paris said that's nonsense. You can't suspend the award waiting for this interpretation. So it goes back to another Tribunal de Grande Instance, first instance court, who orders an exequatur and garnishes a World Bank account, which is belonging to effectively with assets that should have been paid to Yugoslavia. And that's what this case may have become about at that point. The Tribunal de Grande Instance then says, hang on a second, but the 1950 agreement blocks this. It goes up to the Cour d'Appel de Paris, and they express the view that the arbitrators can't go around rewriting international agreements. The Cour de Cassation finally wakes up the system by observing that that SCE wasn't a party to the 1950 deal and therefore isn't bound by it. So it goes back to another Cour d'Appel, this time in Orléans, who say, well, the award was completely wrong, can't be enforced. That goes back to the Cour de Cassation, who says, well, we don't care whether the award's wrong. That's not what enforcement's about. Goes back to the Cour d'Appel de Rouen now, who now say, well, there wasn't any annulment and arbitrators can go around interpreting agreements. And anyway, sovereign immunity from jurisdiction was waived under the arbitration agreement. And that starts to be the winning move because the Cour de Cassation in France goes, well, first of all, it doesn't matter whether it's set aside now, because Paybalk and Norse law has concluded that in French law, the setting aside of an award in the place of arbitration is not a ground for refusing enforcement. There were some side effects of SE in Yugoslavia. By the way, there were some Swiss cases which reached a similar view. This award isn't sufficiently Swiss for us to set it aside. The Cour d'Appel de Paris in the 1970s refused to set aside an award, even though the parties agreed to France's seat, same as SE in Yugoslavia. They said it's not really French. It's an ICC case between the Libyan government and a Swedish shipbuilding company. The Swedes enforced it, even while the setting aside proceedings were ongoing before they'd been rejected. The French NCPC, I mentioned that it's a bit like Beaujolais Nouveau. The N stands for nouveau, new. In 1981, the French legislature, admittedly it was done by decree to avoid it going through a full parliamentary procedure, changed arbitration law to make it absolutely clear that if France is the seat of arbitration, the award can be set aside by an application to the Cour d'Appel, the Court of Appeal, of the seat of arbitration. That killed Gotha-Wirken. In the 1980s, mid-1980s, Marcel Stormer, a law professor and lawyer in Belgium, based in Ghent, he proposed a change to the Code Judiciaire, the way in which the Belgians had in fact sought to enact the uniform law from Strasbourg. And the idea was that if neither party was Belgian in any sense, then there would be no setting aside proceedings, whether the parties agreed to them or not. This was a bit extreme, but was designed to appeal to sovereign states, actually, who really don't like being dragged through the national courts. And in that respect, The Belgian statute was interesting, although it was based actually on a statement to Parliament so full of mistakes, it was almost weird. Around the late 1980s, somebody noticed that the obscure canton in Switzerland of Thurgau, who'd never ratified the Concordat, cantons have to ratify and adopt wholesale a Concordat or just reject it, and Thurgau had never done anything. And their civil procedure law, unlike that of Zurich, who were quite late ratifiers of the Concordat, just didn't provide for setting aside proceedings, and nobody quite knew what would happen if you had an arbitration, a seat of arbitrations in Thurgau, or Thurgau to pronounce it in French. If the parties wished to set aside the award, nobody quite knew what the grounds were. So one could jokingly say that Thurgau and Belgium, quite unknowingly, had become strangers in paradise. Well, it didn't last very long because Thurgau ratified the Concordat, which was a little disappointing. What's come out of this in the end is that the Swiss LDIP provided that the parties can, by an express declaration, exclude setting aside proceedings. The Swiss statute is quite clear that it could be that the exclusion can cover one, not all, the setting aside grounds, or the lot. You can choose which ones you want. Sweden adopted this originally actually in a case, the Solal Bonne in Uganda case. They made the comment, the Swedish Supreme Court did, and the Belgians, when they got rid of 1717-4, replaced it with a Swiss type rule. The point though here is that the exclusion of setting aside proceedings must be done expressly. It cannot be done by reference to an arbitration institution. So it's designed to make sure people don't do it by accident. And it's not widely used in practice. So André Panchaud's article of 1966 leads us to the Concordat, but it also leads us to the model law, the English 1996 Act. He makes it quite clear, Panchaud, that it's not the physical place. Occasionally you get, though, weird moments. Hiscox and Outhwaite was a particularly messy one, where Bob McCrindle, a well-known English QC or silk barrister, had gone to work at Sherman and Sterling in Paris, and he was appointed to be the arbitrator in this case, and he rather carelessly signed it as award and noted that he'd signed it in Paris, which is where he lived at the time. The seat of arbitration was supposed to be England. And if you read the New York Convention, you can understand why the English courts concluded that the New York Convention now suddenly applied to this case. However, they didn't say that the seat wasn't somewhere else. So they still applied the grounds of the now found in section 69 of the Arbitration Act, and allowed setting aside proceedings to continue in accordance with those provisions. It was a right old mess and everybody knew it. And by statute, in the 1996 Act, the English made it clear that the place in which the award is rendered is actually the legal place, not the physical place, which is probably a good idea. In the US, there were some problems with awards which followed agreements that didn't say parties agreed to have the award confirmed in the seat of arbitration. The case law is all over the place, and the case, or the problem, never reached the Supreme Court, who I suspect would have probably hit it over the head and stopped the problem. But you do see this in arbitration agreements. We agree that the award can be confirmed in the seat of arbitration. It just tidies it up a bit. Paybalka-Norsa law is another sort of leftover of SE in Yugoslavia. If Monsieur Auburn's floating award needed any support, it probably came from Paybalka-Norsa law. The award was set aside in Vienna. Actually, the case was the decision had already been reversed by the Supreme Court by the time the French Court of Cassation got its hands on the problem, but the French court treated it as the award as if it had been set aside, and concluded that since setting aside isn't a defense to our enforcement in French domestic law, who cares that Article 51E of the New York Convention provides that setting aside of the award in the place of arbitration is a ground for refusing enforcement. It isn't a ground for refusing enforcement in France. In the US, Cromwell, the US court was so horrified by the setting aside decision, said we're not recognizing that, so we're enforcing the award. Slightly more controlled approach can be found in Baker Marine, who said, look, treat this a bit like the standards for enforcing foreign judgments, only if the setting aside judgment is so appalling or the tribunal is so biased that we wouldn't have enforced such a judgment, will we enforce an award that's been set aside in its place of origin. And UCOS in Holland, well, they just sort of, Dutch in fact, applied the Baker Marine standard to conclude that a Russian court was biased, corrupt, and therefore, when it set aside the award, it didn't bar enforcement in Holland. And we see traces of that in England because there was an attempt to rely on the Dutch decision in England by the man who's now Lord Hamblin in England. He was reversed on appeal, but only on the basis that English public policy and Dutch public policy are inevitably slightly different. The French view got its sort of comeuppance, if you like, when in Hill Martin, an award was rendered dismissing the claim, and it was converted, or was exequatured in France. An enforcement order was sought for this award. And then subsequently, after the setting aside proceedings, the arbitrator issued an award for $1 million on exactly the same facts. And the French court said, look, it's a matter of public policy that we cannot have two conflicting judgments in the system. So the first one binds. We can't enforce the second award following the setting aside proceedings. The seat of arbitration had its heyday, if you like, in the 70s, 80s, 90s. Look, it's terribly easy to find, which does help. And all the statutes make it clear these days that you can set aside an award in the seat of arbitration, at least unless you've expressly agreed to exclude such proceedings. But things never stay quite the same, and we've seen how in the 80s, the French started enforcing awards set aside in the seat of arbitration. It's becoming more common, actually. There's always been a discussion that it says in the New York Convention that recognition and enforcement of the award may, not must, be refused. Actually, a German proposal which said shall be refused was, well, it wasn't really debated at the New York Arbitration Convention conference, which has led Albert Jan Vandenberg to say you shouldn't really take too much, pay too much attention to the German proposal and suggest that may means something significant here. But it does. The Court of Arbitration for Sport has its seat of arbitration in Lausanne, but it doesn't really operate there necessarily. And what do we do with cyberspace? Well, at the moment, it's not the issue it might be, because a lot of the cyberspace decision-making is done through institutions which actually do have physical places, which could be the seat of arbitration or tend to be. So the Hong Kong International Arbitration Center may appoint me to do a case. I'll do it, but they will actually render the award through their institution. Although my signature, if required, will go on it from my front room in London. The tricky bit, of course, is that if you are going to start having cases wandering away from the seat of arbitration, you can have difficulties finding a court that's prepared to help. There is a story doing the rounds, can't support it with a reference, of a case arising out of the Salt Lake City Olympics, where the local court's help was needed to get hold of certain documents. And ultimately, the relevant Court of Appeals found that, yes, a local court could help an arbitration that was taking place in Switzerland, at least notionally, although physically it was obviously in Salt Lake City. If we start to look at what arbitration law really looks like, we try to keep the mandatory rules out. We like the parties to choose. We try not to intervene, but we support. That's the line most courts take. And that's the idea. If you're going to draft an arbitration agreement, you don't have the seat of arbitration, you're causing chaos. You don't know what arbitration law is going to apply to anything. You also must have, if you can possibly agree to it, a law governing the merits. It's very difficult to run a contract if you don't know the standards that are applicable to it. The development of non-legal standards in the form of the lex mercatoria, or at least non-fixed legal standards, led, in fact, to an increase in choices of law, quite noticeably. Parties no longer trusted arbitrators to select a clearly and obviously identifiable law. But Enker and Chubb and Kabadji have led parties to now need to say what the law applicable to the arbitration agreement is. It shouldn't really be necessary, because it should always be the seat, and maybe that should be the clause, the term that should be in the arbitration clause. You do need to work out whether you're going institutional or ad hoc, and if you're going ad hoc, you must have some sort of appointment mechanism. Now, a number of legal systems, notably England, have it built into their legislation that if the parties haven't agreed to an appointment mechanism, that it will follow a certain sequence, and that can get you out of difficulties. There are many cases known where people have just written in an arbitration agreement, arbitration, London, and you just extrapolate from that how to set the arbitration up. It's nice if you've identified some procedural rules. The UNSTRAL rules created by the United Nations Commission on International Trade Law provide a sort of off-the-shelf version if you need it. If there's any question mark about what language the proceedings are going to take place, it makes sense to agree to that. If you're talking about the US, going for the US seat, I'd want to go into judgment provision, particularly also if I was going to enforce an award in the US or saw that as being a possibility, because I do not want some of the lower courts, the Court of Appeals of the US, to have their latest bright idea shown up to the world of rejecting enforcement on the basis of forum non conveniens. That's not a ground for resisting enforcement under the New York Convention, to which the United States of America is in fact a party. But let's put it in there just to be on the safe side. Let's have a look at jurisdictional issues now. We'll find that they really divide into a number of different categories, which are often blurred in the literature. The first issue is, have you got an agreement? Then you've got to decide, if you have one, whether it's wide enough. Does it pick the disputes up? Does it pick up the parties? Then you've got this rather strange phenomenon of ultra and infra petita. I hate using the Latin here, but ultra means going beyond what the parties have claimed. The focus here is not on the agreement of the parties, but on their claims. And infra petita means not getting all the claims dealt with. It's quite customary for arbitrators to say at the end of their awards, and all other claims are dismissed, as a way of avoiding that problem or any other claims. Excess of jurisdiction is the final category, and it depends a bit on where you are. In English law, as a result of the Lesotho Highlands case, if you start off with jurisdiction over the dispute, the only way you can exceed jurisdiction is by awarding something that the parties have expressly agreed you will not be allowed to award. How you get there, what you do in between, is not a matter of jurisdiction. And that's important in ICC or LCIA cases, where the institutional rules expressly contain an exclusion of the right of appeal to the national courts on a question of law. In the USA, Stolt-Nielsen added a new wrinkle, if you like, and concluded that ignoring the parties' agreement and the applicable law would be a form of excess of jurisdiction. The court slightly rode back in Oxford Health by pointing out that where the arbitrator had purported to try to apply the parties' agreement and the law, but got it wrong, that would not be an excess of jurisdiction. It's a pretty fine line here, and it's very unhappy case law that it's based on. There are two strands to it. There's the Boise Cascade case in the 1980s, which I'm not sure a lot of people know, but which took a similar sort of approach to Stolt-Nielsen. There is also the long string of cases on manifest disregard of the law, which was always thought to be a separate category of ground for setting aside an award, not found in the Federal Arbitration Act, but somehow implied, well, the only way to imply it into the Federal Arbitration Act was to treat it as a form of excess of jurisdiction, which is stretching it a bit. And we all thought that after the Hall Street judgment of Justice Souter, which is strictly speaking obiter, doesn't actually cover the issue, but Justice Souter basically said manifest disregard of the law is wrong. It's not a ground for setting aside an award. It's based on a comment made in Wilco and Swan, case about subject matter arbitrability. And Wilco and Swan hasn't been good law since the 1980s. What law do we apply to jurisdictional issues? Well, I say almost always because of Kebabji and Enka and Chubb. You can have, obviously, an agreement to make your arbitration agreement governed by something else than the seat. You certainly shouldn't do that because it causes chaos. But in principle, that's how it should be. But of course, Kebabji concludes the next best choice of law governing the contract without an express choice of law governing the arbitration agreement can produce the effect, unless the drafting makes it clear to the contrary, that the choice of law to govern the main contract will also apply to the arbitration clause. Not comfortable. In fact, where no seat has been chosen, it does get a bit messy anyway, because you haven't really got anything to bite against. It would actually be better just to treat the court dealing with the problem that it should be their law. But once we've got a seat of arbitration, we really ought to streamline these things. But that's not how the law is going at the moment. You do find some mandatory laws. The Swiss notably have a rule that says, as do the Dutch, that there is a series of possible laws that you could apply. The Swiss, the law governing the merits, law governing the contract, typically, law governing the arbitration agreement, and the law of the seat. If any of them make the arbitration agreement valid, it is valid, and that includes valid in relation to parties that may not be named in the arbitration agreement. So if French law governs the main contract, seat of arbitration in Switzerland, the Swiss court will apply the Dow Chemicals case law and typically extend the arbitration agreement to any party or any participant who, by their participation in the performance of the contract, has evinced an intention to be a party to the agreement, notably at least where that performance has been accepted by the other parties. But for other issues, such as formal validity, it's the seat of arbitration that is applicable. The French take a wonderfully French approach. They say, well, if it's an international arbitration, the principles of international arbitration law apply, which in their case are actually the French principles. And so they apply French law to just about everything, which at least gives you a degree of consistency. And since French law in relation to international arbitration has a lot to be said for it, and nice and simple, you don't get funny tripwires wrecking things. This is a picture, by the way, of Laurie Craig, who was the arbitrator in the Boma Oil case and one of the most distinguished arbitration practitioners of his generation. The New York Convention says that we mean by a written agreement, that's the French version, by the way, one that is signed by the parties or contained an exchange of letters or telegrams, it should say. Now, the Swiss and Austral model law go a bit further, and they say it should be an agreement that goes further by relaxing the rules slightly. Agreement is formally valid if it's evidenced by writing. That's the Swiss LDIP. Before the LDIP, the arbitration agreement had to be signed by the parties. It caused chaos. It still can cause chaos if you have a telephone conversation, which may be taped, of parties agreeing to arbitrate under certain rules or arbitrate generally. The increasing consensus has become, we don't need writing, we just have to have an agreement to a written document. And the Belgians and the French, at least international cases, don't require formal validity, except that they do expect you to, when you apply to enforce the award, to show up with your copy of the arbitration agreement. So you could have an oral agreement to a written document and you wouldn't have an enforcement problem. In truth, the exchange of letters and telegrams, which was required in the original New York Convention Article 2.2 definition, used to cause problems, particularly when telexes became quite common. The Swiss in the Trade Acts and Amico case took the view, which is I think slightly the wrong way around, that telex was equivalent to a telegram. Well, it's actually equivalent to a letter, and an exchange of letters is good enough for the New York Convention. Now with emails, Instagram messages, all kinds of instant messaging, the exchange of letters requirement doesn't catch nearly as many people as it used to. Finally, though, the Swedes have traditionally never had a formal validity requirement and still don't, nor does the Austral version 2. Interestingly, in order to waive your rights to a fair hearing under Article 6 of the European Convention on Human Rights, the European Court of Human Rights does not require any form of written agreement, just an agreement in general. Formal validity is going out of fashion. Incorporation by reference does cause its fair share of problems and depends a little bit on the way the judge tackles the problem. You see, the parties may not have seen the arbitration clause, but if they agree to a standard form agreement that contains one, it becomes almost a matter of local law as to whether or not the unseen document, which typically is available to the parties if they want to get a copy, it has actually been properly incorporated. There can sometimes be problems when you try and incorporate one agreement into another. Typically, this is incorporating the terms of the charter party into a bill of lading, that the two agreements just don't fit together properly. But increasingly, the trend is actually away from the Thomas and Portsay sort of English approach of being frightfully sniffy and saying, well, if you're going to incorporate an agreement to arbitrate, you better do it clearly, into saying, well, the parties know what's there, you know, to allow parties to escape wouldn't do it. There was also a slight question mark about formal validity here, and Article 2 of the New York Convention, actually, Article 2.2, because you don't really have a signed exchange of letters or telegrams, or any sort of exchange of letters or telegrams, I should say, because the signature is not required on that exchange, which contains the arbitration agreement. But you can argue very strongly that if we have an exchange of letters or telegrams, or even a written document signed that says incorporated into our agreement is a certain document which happens to contain an arbitration agreement, as long as it's the party against whom the agreement is sought to be enforced has a reasonable opportunity to get hold of a copy, that should be good enough, particularly in a commercial transaction. But you could have an Article 2.2 problem, and this issue has been raised over the years. There are a number of elements to the multi-party problem. The first problem is, can you extend the arbitration agreement to people I would like to call unnamed parties or non-named parties? You sometimes hear the expression non-signatory, but since the parties don't need to sign the arbitration agreement anyway, a non-signatory party is typically everyone, and I would like to get rid of that expression. You could stretch an arbitration agreement anyway to a party that's not named there, on the basis that a party that is named is contracting on behalf of an undisclosed principal. You can sometimes pierce corporate veils. The SGTM and Bangladesh case is a good example of one where there should have been a piercing of the corporate veil. The government of Bangladesh, desperate to get out of obligations that had been incurred by the East Pakistan Development Corporation, did a sort of double weird maneuver of getting rid of the original organization, replacing it with something else, and then ultimately closing that organization down. It would have been fairly legitimate to say that the government of Bangladesh should use the corporate veil as an instrument of some form of fraud. I suppose one could be more sympathetic and say a new state wants to get rid of some of the old obligations it has inherited, is entitled to use some of the corporate forms to achieve this. Whether that's an acceptable view, I don't know. I will say about SGTM and Bangladesh that it was never argued, as far as I can tell, that there was, or there should have been, a piercing of the corporate veil. You do get two types of arguments here. Sometimes you have contracts that incorporate other contracts expressly, typically, and that can get you a whole range of different parties if you're not careful. You also have this problem found in French law, starting with the Dow Chemicals case, but going through lots of other ones like Sponsor and KISS. This produces the idea that parties that are not named in the agreement may become parties to it by their performance, particularly if you think about it, if the other side has no objection to that performance being delivered. Those people who remember their sort of law school days from the 1970s, as I do, might recall a case called the Eurymedon, decided by the Privy Council in 1977 or 78, in which the stevedores, when they unloaded the sugar, I think it was, or cargo, were deemed to have accepted an offer that was made to them of the contract terms. The unilateral contract became bilateral by their act of unloading the cargo. And I sometimes wonder whether that's not particularly different from the French approach. And in the Paris Court d'Appel, in the Dalla case, the government of Pakistan took over that transaction pretty early on, and even went to court to try and stop proceedings in the arbitration. They went to court of Pakistan, and their activity could only make sense if they had taken over from the trust, which actually lapsed by operation of law. You do have problems with multi-party arbitrations, as the Duck case shows, because you can have bias issues. If you have more than two parties, if two parties are required to share the appointment of an arbitrator and another party is entitled to appoint its own, you may have a natural justice issue. And the result is that most institutions now have rules that in multi-party cases, or in any other, the institution is entitled to approve of an arbitrator. But if the institution has appointed somebody in an existing case and it becomes multi-party, the institution reserves the right to remove the arbitrator and have another go, and you end up with slightly more sensible tribunals. You can have 5 parties and 3 arbitrators. It makes much more sense. A slightly different question concerns whether or not proceedings arising out of different contracts can be consolidated. Well, you can always draft this, make it possible that parties agree to this happening, then it can happen. It can be messy, however. Do be aware of that. In the USA, Stolt-Nielsen, following a case actually called Boeing in US, the Supreme Court in Stolt-Nielsen said you can't go around producing a class action arbitration by agreement. That's except by agreement. And in Stolt-Nielsen, there was no agreement to do that. There were lots of different people who contracted with Stolt-Nielsen who now wanted to bring a class action claim against them. And the Supreme Court said, not without express provision in the contract. You all have arbitration clauses with Stolt-Nielsen, but not to have them together. The Dutch originally said that the court in Amsterdam could consolidate if the parties had not agreed to it, so long as they hadn't excluded the possibility. Now you can actually appoint an arbitration institution or a disputes board, as I've suggested here, that could organize the consolidation for you. There's been a singular lack of case law on this, which is probably a reflection of the fact that the parties know that the court will consolidate an arbitration where it makes sense, and so agree gently to come without actually bothering to have a fight about it. If you read the Swiss rules, it looks as though the institution can actually join parties together without their agreement. In practice, the institution won't do this without parties' consent, but it's always an outside possibility that where it makes sense and the parties don't agree to it, the Swiss rules institution will in fact join parties together in various different forms and say, look, by agreeing to arbitrate under the Swiss rules, you've agreed to let us make these sort of decisions, even though now you're not so sure you really want us to make those decisions. Unless all the parties can agree, there won't be any joinder. You can see where the Swiss rules are coming from. Typically, institutions will consolidate cases with the parties' agreements. They'll fix the two together. It matters quite a lot, actually, that these arrangements are put together properly because they can affect the charges that the institution levies. The great reason for consolidating, or at least holding cases concurrently with the same tribunal, is that you don't want conflicting results. In fact, there is quite a good case for agreeing to concurrent rather than consolidated arbitration, because there may be discrete issues which don't work very well dealt with together. You might be wiser to siphon off bits of the dispute, but an arbitration which is consolidated can always have deconsolidated bits to it. There's nothing to require that. But it does help where you've got a chain contract with different people taking different profit margins, if you actually have a concurrently held case, because each award has the figures calculated separately, which is a good deal more straightforward if you're trying to enforce the award. Separability has two different meanings. We've seen earlier on that the arbitration law has prescribed in virtually everywhere in the world that the law applicable to the arbitration clause, typically the seat of arbitration, but as we know from Kebabji, not always, may be different from that governing the main contract. And even Inca and Chubb and Kebabji in England accept that. Where the English part company, I think, with the French more than anybody else, is in not seeing the law applicable to the arbitration clause as an issue quite distinct from the law governing the main contract. The Supreme Court seems to merge the two issues, which I'm not sure is helpful, and it does result in the slightly absurd outcome that you find in Kebabji of an award rendered in France pursuant to agreement providing for arbitration in France that can't be enforced in England. The second meaning of separability is the main contract's nullity or voidness doesn't knock the main contract out. Now, over the years, a number of countries think they've adopted separability in the second type in situations where because of the partial enforceability of contracts, they may not have actually done so. You don't really have separability until you've got a main contract that's void, either because the parties never agreed to the main contract or because the contract is void, not voidable, for illegality. Pretty much anything else can be explained away by ordinary contract law. In the Fiona Trust English case, the Supreme Court went for the double option of making it very clear, and it's becoming increasingly popular, this view, that no contract does not mean no arbitration clause that's contained in it, because during the negotiation of an agreement, you may agree the arbitration clause without any doubt, and then there may be a subsequent argument about whether the overall contract was ever concluded. The English Supreme Court thought it was following the Germans here, actually was following the Swedes in a case called Hermansson, which makes this point very clearly. There's a more recent Swiss decision a few years ago, not brilliantly well worded, but definitely saying just because there isn't a main contract does not mean the arbitration clause is unenforceable. The tricky one is assignments. Now, remember though, the assignment must be valid under its applicable law. So in Kebabji, the licensee or franchisee was passed the contract rights to the parent company, but they didn't get the consent of, the Lebanese company, Kebabji. And the English court said, well, in English law, that's not a valid assignment. It may be a transfer of some description, but you actually do need the consent of the parties. If you do have the consent of the parties, the general assumption is that if you do assign an agreement that includes the arbitration clause contained in it, it demonstrates that not that the arbitration clause isn't separable, it just demonstrates that a contract containing an arbitration clause has two agreements in it, both of which can be assigned together or separately. It rather exposes the fact there is separability started life off in its second form as a presumption of survivability the parties could exclude. The English, by the way, in Vienna Trust relied heavily on the German Supreme Court decision of 1970, which makes the point the parties, when they agree to arbitrate, assume that the decisions in their case will all be made through the arbitration route, not half and half. So not the court determining whether there's an agreement and then the arbitrator, if they decide there is an agreement, the arbitrator then proceeding to determine the damages or whether there's been a breach of it. So there is another assumption, if you like, that the parties intended one tribunal, and that being the arbitration agreement, in the event that the parties have actually agreed to arbitrate. Subject matter arbitrability is a vast topic in real terms. Some countries just say, well, look, we won't allow arbitration if an arbitration will be contrary to public policy. The tradition in Belgium and France is to do and Holland is to say, well, if you can settle the dispute, you can arbitrate it. The Belgians have sometimes interpreted that to make this issue determined by the law governing the substance of the dispute, which seems to be a bit the wrong way around. The Swiss and Belgians now talk about anything being valid in money terms being arbitrable. The Swiss recently said that Swiss Tribunal Fédéral said you can't arbitrate a dispute where it would interfere with bankruptcy proceedings, even though anything valid in money terms it would be, can be arbitrated. So there is the occasional break on this. The reason why some people say that criminal matters can't be arbitrated has nothing to do with the criminality of the matter. It does have everything, though, to do with the punishments. The French statute, Article 2060 of the French Code Civil, has been causing muddle and confusion for an awfully long time. An arbitrator obviously can't break public policy. Can they rule with jurisdiction that public policy has been infringed is one of the big questions that has never really got a proper answer. Might be better if they got rid of Article 2060. If we try and break this down a bit better, competition law has always had the problem that an arbitrator can't grant an exemption in European competition law for an agreement that is in breach of competition law, and such an agreement is void. But remember, separability means the arbitrator can reach a decision that the contract is void. There used to be a question mark where parties were seeking individual exemptions during the case and then seeking an adjournment to the arbitration, which the arbitrator probably should just say it's void. Terribly sorry you didn't get an exemption in time. The Swiss have taken a very odd approach here. They have decided that where the contract concerned European markets and a claim has been brought for breach of EU competition law, even though the seat of arbitration is in Switzerland, a country that's not in the EU, the Swiss competition law claims should be considered, but they refused to set aside an award where the arbitrator misapplied EU competition law. There is a certain logic to it if you think about it. If the arbitrator at least has a go, they're all right. The difficulty here is that if you think about it, Swiss competition law will not apply to activity that has no effects on a Swiss market. And so some competition law must be applicable. And the obvious way to do it is to say it's the law of the seat of, not of the seat of arbitration or of the law governing the merits, but actually the markets that are actually affected. And that's probably what was behind the decision in Mitsubishi and Solar in the US Supreme Court, which concluded that the arbitrator seated in Japan applying Swiss law to the merits of the contract would still be expected to apply US antitrust law to the question of whether the ban that Mitsubishi placed on Solar from transshipping cars that Solar was having problems selling in Puerto Rico over to Florida, where Mitsubishi already had a distributor, would, the argument about whether that ban would be a breach of US competition law would still be decided by the arbitrator in Japan. It sounded absurd at the time, but the more you think about it, the market, or the only market that would be under consideration for a claim in relation to competition law, would be the US market. And so actually, I think an arbitrator in that situation should apply US antitrust law to the exclusion of Swiss law, because Swiss competition law would obviously have no impact at all here, no application. The Belgians traditionally have been very twitchy about the Exclusive Distributorship Act, difficult to say. And this law, by the way, which goes back to 1961, was subsequently incorporated in the commercial code, so it has different numbering and labeling. Either way, you don't mess with the Belgian Cour de Cassation in this area. They don't allow arbitrations to take place in this space. I should, I suppose, before I move on to patent validity, mention an Austrian Supreme Court decision where the court refused to enforce an arbitration agreement where the arbitrator seated in the US had declined to apply EU competition law to a case that related to an EU market. The Austrians took the view, and I can see their point here, that they were not going to allow to go ahead any sort of proceeding which could be used to bypass the mandatory applicable competition law. Patent validity has always been tricky because the granting of a patent, of course, restricts competition. And there's always been the view that if a national court has exclusive jurisdiction in this space, typically a patent court, as it's the case in Belgium and Holland and France, that somehow you couldn't arbitrate a dispute. Whether that's correct or not is slightly open to question. The US in 1983, before Mitsubishi was decided, thought they better clear up this question. So they said, well, you can arbitrate a patent dispute, but if the patent is subsequently declared void, you can have the decision revisited by the arbitrators. I don't know of the experience with the 1983 law and whether it's worked. The French Tinet case makes it very clear that arbitration in the context of a company that's bankrupt could be a problem, at least without the court's authorization. And there's been some confusion in the US because of conflicting results. The Sonatrach case in the 1980s at first instance suggested that in an international arbitration, the US court wouldn't be interested or worried by an insolvency procedure somewhere else. It's more likely to be close to home, and we've seen already the Swiss saying that they're not prepared to regard as arbitrable and otherwise permissible arbitration where a party is already part of insolvency proceedings. English insolvency law also makes a similar point. Typically, the judge is required to sign off to protect the other creditors of the company. There are lots of ways you can challenge jurisdiction. I'm sure there are more than the ones I'm putting on the screen here. You can bring a court case in breach of the agreement. You can seek an injunction either to stop litigation or stop the arbitration. And that either way, you're going to bring it in. West Tankers at European level, EU level, stops an injunction being granted where Lugano-Brussels regulation applies, if to stop proceedings taking place within countries covered by the regulation. Obviously, it wouldn't cover the Soviet Union or Russia as it now is, and other countries outside the EU framework. You could refuse to appoint an arbitrator and thereby say, look, don't appoint an arbitrator court because it's an invalid arbitration agreement. Oh, applying to court for a declaration used to be a common play in Sweden, but now it's limited to consumer cases. You could apply to the US for an injunction, or you could apply on a motion to compel arbitration under the Federal Arbitration Act. That'll work. You can seek an injunction in England, but not if you're participating in the arbitrator's proceedings, or you could get a ruling from the court if the arbitrators can agree to you doing so, or both parties, or the other party consents. The court does have a little bit of a filter and make sure it makes sense to make a ruling at that stage. You could ask the arbitrator to decline jurisdiction. They don't do it very often, but you never know. You could apply to set aside the award. You could stop enforcement of the award. The ICC has its own procedure whereby they won't start an arbitration off if, following a submission from one of the parties, the Court of Arbitration concludes that there is obviously no arbitration agreement. There is arguably one, they'll send it to the arbitrators. This is one of the most misused terms of our time. It could mean lots of different things. At its very limit, we go back to an English case called Christopher Brown. In that case was an enforcement one, and I'm pretty sure that the respondent didn't participate. And Mr. Justice Devlin noted that just because a party says that the arbitrator doesn't have jurisdiction does not prevent the completion of the arbitration and the issuing of a valid award. In that respect, the arbitrator has the right to rule in his own jurisdiction. In truth, if you are a judge in any sense and your jurisdiction is brought into question, you do have to ask the question, do I have the power to do what I'm doing? And if not, I should stop. And that's the very minimalist level. But actually what it comes down to is, when can you challenge jurisdiction and the extent to which you can do that challenge. So in that respect, it's a case of not do you have competence, but do you have more of it or do you have less of it, judged by these terms. Now, there is a traditional definition of competence, which is German actually, and therefore best pronounced with a K, where the parties give the arbitrators the power to make that binding decision. The problem with the Henry Schein case was that the parties merely agreed to arbitrate under the rules of the American Arbitration Association, which in common with many others around the world, says that the arbitrator has the power to rule in his own jurisdiction. Did the parties, who undoubtedly agreed to arbitrate their dispute, but deliberately said that there must be no claims for injunction dealt with by the arbitration, did they agree by submitting, if you like, by agreement to the American Arbitration Association, to its arbitrator making that ruling in a binding way? The expert opinion provided by the American Law Institute, and George Berman, the arbitration reporter for its restatement, went to the Supreme Court and said that is nonsense, notwithstanding a decision of the First Circuit, that's the one in Boston, that bit of the world, which says that agreeing to arbitrate under the ICC rules is in fact a competence agreement. That is not the case. Now, the Supreme Court never got to decide the point in Henry Schein. They decided the whole point was the whole case was a bit pointless, and halfway through dropped it. So we'll never quite know their view, but the US courts are the only ones that have ever taken the view that an institutional agreement to arbitrate excludes court review. And I think the rest of the world's right. So at the minimal level, you can have, as we've seen in the US, an application to court for an injunction or a motion to compel arbitration in the USA. You've got to be a bit careful here because there is some literature suggesting that that really shouldn't happen, particularly in institutional cases where there is this agreement or this rule provision that the arbitrator has the right to rule in his own jurisdiction. In England, if you choose not to participate in the arbitration procedure, go straight to court, you have effectively removed the power of the arbitrator to rule in his own jurisdiction. And then you've seen the ground for going to court, either with the party's consent or the arbitrator's consent. By the way, the jurisdictional nature of the problem can be seen by the fact that the court has to give permission to such an application being brought to the English courts. In England and in the US, if there's an application to the court to stay proceedings or dismiss them on the basis of a valid arbitration agreement, the court will determine the jurisdictional point. So if you pull apart the English provisions, yes, the arbitrator can rule in his own jurisdiction. That's Christopher Brown. They are entitled to make an award on jurisdiction or a final award. In the old days, you could go straight off to court while still participating in the arbitration for a ruling declaration that the arbitration agreement was invalid or didn't cover the dispute. There is inevitably, as there are in all countries, a requirement that any jurisdictional issue must be picked up promptly or it will be given up or waived. And in England, like Switzerland, if you don't apply to set aside the award within the time limits, you give up your right to the objection. But we've seen that under section 32, if all parties agree and the arbitrator agree, if all parties agree, then the court can deal with it. And also the court can deal with it if the arbitrator agrees and takes the view that substantial savings will be likely if we get on with it, don't have a ruling on jurisdiction, and the court thinks that would be a good idea. There's also the application of a non-participating party for an injunction. If you do it quickly and you lose on the injunction application, you can still participate later in the arbitration, which is probably the right way to do it. There's, of course, the setting aside proceedings, staying litigation. There is a bit of a question mark about applications to appoint an arbitrator. There is case law that suggests that there's actually only a surface check, but if you think about it, if somebody applies to the court to appoint an arbitrator and you don't think the arbitrator's got jurisdiction, the smart thing to do is to respond to it by applying for an injunction under section 72. Then there's enforcement proceedings. We're seeing increasingly, we've seen it with England, we see it with Switzerland, this sort of, and Sweden, this discretion now given to the arbitrator to merge jurisdiction and the merits or keep them separate. If you issue a decision on jurisdiction, can be immediately attacked, which has a lot to be said for it, in one sense, in that you don't end up with awards being on the merits that then get set aside for jurisdictional reasons. The second approach we find in France, Belgium, and Holland is only setting aside proceedings after a final award. Do please realize, though, that if the arbitrator says, I don't have jurisdiction, that is a final award and can be challenged in those countries. It can't, however, be challenged under the unstrong model law, of which more in a moment. On austere dismissal, the Swiss take a slightly quixotic view that if the seat of arbitration is in Switzerland, the statement that the arbitrator has the right to rule in his own jurisdiction means, and there's no provision in the statute that actually says this, that the court will refer the parties to arbitration if at least it's arguable there's a valid arbitration agreement. But if the seat is somewhere else, they say the New York Convention mandatorily applies and they will run the tests of Article 2. And if the agreement doesn't match up to Article 2, they will continue with their court proceedings. In France, the French court will only continue with court proceedings if the arbitration hasn't started, or it considers, if the arbitration has started, that there is no argument, no sensible argument, that the arbitrator has jurisdiction. Strangely, the unstrong model law, and I say strangely because this was pointed out at the time in 1985, and it should have been put right, at least in 2006, there should be a ground to set aside an award where the arbitrators decline jurisdiction. This is more of a problem than you think. If you're an arbitrator and it's a bit of a fine line case, the temptation is always to find you do have jurisdiction and then invite a party that disagrees with you to go to court, because if you find you don't have jurisdiction and you're wrong, you've just deprived one of the parties, typically the claimant, of course, of the right to arbitrate their dispute. The Swiss Supreme Court will not review the facts found by the arbitrator, which is a bit bizarre. If you need a case for that, the Westinghouse case will do it. And so if the arbitrator finds facts that supports a conclusion that there is jurisdiction, but finds them wrongly, there is effectively no redress. Otherwise, the view is that you get a full look at the facts and law. When you're appointing arbitrators, as I said, England and Sweden, you just apply for England, you just apply for an injunction. I'm not sure actually about Sweden being correct, but the US, you certainly get a full review on the wording of the Act anyway, Federal Arbitration Act. That's the England caveat. There's an arguable test in France and Switzerland, and no review at all in Belgium and Holland. I wonder what would happen, though, if a court in Belgium and Holland were faced with an application to appoint an arbitrator, and it's clear to the court that there is no valid binding arbitration agreement. Would they refuse to make an appointment? I can't tell you the answer there. We're now on basic arbitration procedure, and I'll just simply say that the key point here is that the parties' agreements subject to any public policy concerns about fairness will bind the arbitrators and can override an institution's rules. Although, of course, the institution can decline to administer an arbitration that doesn't comply with its own rules. If the parties haven't agreed on procedure, it's a matter for the arbitrator. So now the tricky bit is the ICC rules say you can't have documents only arbitration unless you've got all party agreement. And Dutch law is pretty clear on the subject. I think other legal systems would take a similar view, which may be unfortunate because occasionally you get parties asking for some sort of hearing and it doesn't make sense. So it may be that there's an error of development in the law. Because one of the awkward questions is we say we want a hearing, but what? You can't hear limitless numbers of witnesses. You've got to have a certain amount of control as an arbitrator and say, well, you know, we can hear 2, but not 7. Otherwise you never finish. So the tribunal's power over its own procedure to get the case to the other end has to include some sort of limitation. It's increasingly pointless to have oral hearings of legal points when they can be put together in writing. It's much more efficient. And at that point, we're ready to request our arbitration, and we're at the end of our video. Thank you very much for listening, and well done if you made it all the way there.